Hello. Welcome to First Friday Fertility. I'm Dr. Preston Parry. I am here with Ashley Pittman, a reproductive attorney who is absolutely phenomenal. We're going to be talking about all kinds of things as to why an attorney may be really valuable for you as you go about the reproductive process. We have so much we're going to talk about. It's going to be a lot of fun. But remember, first of all, this is general legal information for everything. Talk with a physician or your attorney before making any medical or legal issues. So, Ashley, tell us about yourself. Tell us about your background, how you came to this, area of expertise for things.
So I started as a tax lawyer years ago, and I became interested in fertility law because I was looking into the embryo, and I was handling a lot of estates and a lot of heirship issues. Mm-hmm. And I wanted to know more about, how does the embryo play out? Is it an heir? Is it a child? Is it not? What is it? Sort of thing. And so I researched the law at that time around the country, and it was a very small body of law. Yeah. But so that just set me down the path of, just curiosity. And so then it just blossomed from there. And it was just a lot of fun. And so I've transitioned my entire practice into reproductive law. Just
to talk on that, for things, you may not have a monopoly on knowledge. Nobody does in this world.
Sure.
Again, saying that nobody has a monopoly on knowledge. We learn from each other. I would say you have a controlling interest.
Right.
No, Ashley is probably one of the most knowledgeable people I know, but even particularly for reproductive law as a reproductive attorney, just does a phenomenal job with that. And, actually for, again, Reproductive, or I don't know if we can name them, but, one of the largest reproductive companies in the U.S. draws upon Ashley for embryo seeds and things like that. So she has a phenomenal history and is nationally recognized for these skills and not just locally, even though we appreciate her locally. Where should we start? Do you want to go? So when I think about reproductive issues,
right,
for needing an attorney, it's the 4 Ds.
Okay.
Death.
Okay.
Divorce. Donation. Egg donor, gestational carrier for the third-party reproduction, and then diversity. LGBTQ. Thruples. Where the modern family does not look like a Norman Rockwell painting, and we have to address all the permutations with this. Which would you want to? If you had to. Let's choose one. What would you prefer starting out with out of those big 4?
Okay, so let's start with divorce.
Okay.
Right? Okay, so the biggest body of law out there, if we're going to approach it from a legal standpoint, right, is dealing with divorce, because IVF is, relatively speaking, new enough that more people have divorced than died, right?
Correct.
Okay, so in a divorce scenario, there are sort of different genres of law around the country. For the most part, and I have to qualify this, it's state dependent, judge dependent, right? Mm-hmm. Things happen all of the time that, are interesting and different from the baseline law. The divorce, percentages are real, and also infertility is stressful.
Yes.
On a marriage.
Well, and even if you have a very normal couple, they are resilient, they are close. I always say, when I do IVF counseling, I'm saying to people, imagine someone's in a bad car wreck. They take frontal lobe damage to the brain. It controls personality. Mm-hmm. You are now married to a stranger and you have embryos in common. How do you want that to play out?
Right.
And that can be very complex if you haven't gotten the right agreements in advance. So for divorce, what do you think people should really know about when they are sort of saying, hey, let's plan? We know we're going to be together, but just in case you're in that bad car wreck,
right?
What do we do?
Okay, so the first thing that needs to happen is, every IVF clinic, hopefully, is going to present a consent form that is going to give the couple certain options with regard to divorce. And so one person or the other would either be chosen, or they, in the event of divorce, they could actually say no one is going to receive them, and they can also choose, at least here, not in Louisiana, to destroy them, right?
So, and by the way, so the core options for embryos when you're saying we are not going to use them, throughout the U.S. and certain states have restrictions,
Right.
but it is we use them for ourselves.
Mm-hmm.
We donate them to another couple.
Right.
They are to be thawed without transfer, discarded, destroyed, however you use the semantics, or donated to research. And the donated to research, by the way, for those watching,
Right.
while that would be an ideal, the reality is so few places actually will accept them. We searched, and we could only find one place in the entire country that would actually take them for research, and that was only if they were chromosomally tested for being euploid.
Mm-hmm.
And so that even had an impact there. And even then, they may not be doing research anymore on that. So it's very hard to find a place. So that further restricts the option.
That's right. So it's not really an option, right?
Right.
So it's very important to have that serious conversation about, what do we want to happen, and have that conversation regularly, honestly, because, as you go through the IVF process, and you can speak more to this, but at some point, a lot of people determine that their family is complete. And they either move them to long-term storage, but they still have embryos or any sort of gametes still frozen. Yeah. And so that conversation needs to continue. What now? Right? Because it may change.
Right. And, even for those who put them in long-term storage and say, we are not deciding at this very moment, there's a song by Rush called Free Will. And it said, if you choose not to decide, you are still making a choice. Just kicking that can down the road doesn't mean it won't be addressed someday. Right. And you want to do that. By the way, as you go about this, one of the important things, talk with your clinician. Now, again, national average for under 35, 43% of people bring home a baby from a cycle of IVF. Now, we're very proud of our statistics being better, but that's a whole other story. Right. But the point is, if for much of the U.S., the majority of people don't bring home a success, people are more worried about whether they get pregnant than whether they have extra. But at the same time, if you find that you are having robust reserve, that you have a lot of eggs, that you are likely to have extra embryos, you want to have a conversation with your fertility specialist about how many embryos you generate and whether you should even partially freeze eggs. I had a patient today, in her mid to late 30s, and she's saying, we only want one child.
Okay.
And she has robust reserve. Okay. And we are talking with her, okay, we are going to only fertilize 10 eggs. By the way, mid-30s, you're often needing 5 eggs to get one embryo. Average embryo has a 30% chance of taking in the mid-30s. So creating 2 embryos, maybe 3, with 30% chances, that would not leave much buffer.
Yeah.
And she shouldn't have extra embryos that she wouldn't use given her goals. If you are 25, you have a tubal ligation and a new husband, and you get 30 eggs and are likely to get 8 embryos, you may want to talk about whether you only fertilize a subset and then freeze eggs so there aren't as many complex embryo decisions. But for when there are complex decisions.
Right, sure. That's right. And so, and we've talked about also combining, the sort of estate planning aspect of this and the reproductive aspect of it into, you can actually look at a legal trust for your embryos and your gametes. And so that's a conversation that is probably for another day. But
there are some people who, if they divorce, they say, I will, even the guy will say, look, I froze my sperm or these embryos together. You know what? I don't want any additional kids. They're all yours, even if you choose to use them with a different partner or things like that. But you want that spelled out in advance, rather than in the heat of the moment. It's
imperative that it's spelled out in writing that, especially if, let's just take a heterosexual couple, for instance, man, woman, they create embryos together using their gametes, and their divorce decree says she gets, all of the embryos, and she is free to use them as she sees fit. It also needs to state whether he intends to be the parent of any resulting child, right?
And, also, I would assume that, and again, By the way, again, I'm not an attorney. I'm deferring
No,
everything
no,
to Ashley
no.
on this.
Yeah.
But that ultimately, if the woman is to use those embryos, does the source of the sperm, who's now the ex-husband, does he have not only custody or visitation rights, but also does he have responsibilities for support, child support,
Right.
and that really needs to be spelled out.
It really does, and there can be a hybrid there. If both parties agree, but I tell my clients, and there is some gray, but as a general rule, you can't really have it both ways. You are either giving up the parental responsibilities and the rights,
right,
or you're taking the parental responsibilities and the rights.
Exactly.
So as far as child support issue, if you are giving up and you don't intend to parent the child, then don't ask for the child at Christmas,
right?
If you're not going to pay child support, right?
Exactly.
You don't get both. So
but plan it in advance,
right.
And do not forget about these things. Again, have someone who knows about these things, who gets them. What are the agreements for use? What are responsibilities for things? The other thing, and this is going to be state dependent, but also, can you mandate that as part of the decree, if there is a divorce, the embryos are to be dissolved, destroyed, donated, those types of things? And right now, are you aware of states with laws that forbid destruction besides Louisiana?
No.
And so this is something to know, and this may change. So also, as things evolve, be aware of it.
Right.
But if this is something that does change, you may have to sign new consents.
Right.
You may have to address it so the communication is there. And also remember, if you have signed a consent, you may change something verbally. But you know what? If it goes before a court, they will look at the last written version. So you have to have notarized, affirmed, attorney-generated, or whatever documents that would supersede the previous one.
Right.
If there is that goal. So
right.
You need
the last written consent form wins. Right.
So very important to know.
Right.
Okay.
As well as the last will and testament, because we will definitely talk about death as well.
So let's go to for things like that.
As well as the last will and testament, it also will win as far as if it has language in it addressing what to do with genetic material after the death of one party, right?
Yes.
Yeah.
So, I've seen this where all of a sudden, people are having kids later in life, and then all of a sudden a husband has a heart attack or things like that, and they have, embryos remaining, and then they often will donate them to other couples. So what have you seen most for death being relevant for discussion of what happens to DNA and gametes?
So death is very relevant to whether or not, as we discussed with divorce, one party, the deceased, intends to parent the resulting child. And so there's a lot of law in different states that mandates that it has to be in writing, that intent is present. What wins? Well, the consent form, has very specific wishes. And that's usually the first place people go to say, oh, this is what happens to the embryo.
Yeah.
And then, but if the will was executed at a different time and it conflicts with the consent form, what do you do? Because a last will and testament is an individualized document, right? And so for the most part, just taking the couple that we were discussing earlier, those consent forms are a joint consent, right?
Right.
So that's a big quandary.
So are you saying that the joint agreement may supersede the will even if the will is later, because the will cannot be done without the joint permission in some ways if it is done in isolation?
There is case law out there, at least in one state, that says that all decisions with regard to genetic material have to be contemporaneous.
Okay.
And so that comes to mind. This area is so new that you can kind of, in a lot of states that don't really define it well, you can kind of come in from whatever angle is best for your client, right? In whatever position that you're trying to.
Right. Well, and so there are a couple things with this. So first of all, the number one thing is a takeaway: get with a reproductive attorney who knows what she's doing. But then you can also see, so where this can even get more complicated is, for example, if there are embryos that are remaining, and for instance, there's been a divorce, but then and the new wife gets the embryo or variations of that, or the new spouse or the previous spouse, you can actually have it for estates, where if a person has a lot of money in the estate and it is divided among children in the estate, they can actually try to say, okay, I'm going to have more children and bring more money out of the estate from that. So there are some crazy things that can happen, and if you don't think of it, it can go awry.
And that leads me to just a side point. I've realized in my practice, and this is a niche practice, right? And so, I probably look at this issue differently from a lot of other attorneys in the country, but I've realized that when people are sitting at the conference room table and they are going over their estate plan with their estate planning attorney, they're not mentioning embryos.
Right.
The estate planning attorney doesn't really know to put that in the asset listing, right? And so then they possibly are more concerned with grandmother's silver and the traditional, assets that they think about, when everyone thinks about what am I going to leave when I die. The embryo conversation and the gamete conversation is not coming up.
Right.
And so it needs to be top of mind that, your attorney may not even be aware.
So if you have frozen embryos or DNA or sperm or eggs, just remember, make sure you address it in wills, in estate planning, in all those types of things, so that it's addressed.
Yeah, this is a conversation that needs to occur in conjunction with the consent form that you've signed at the IVF clinic, right?
Yes. Now, to go on a different route for also posthumous. So the thing is, we've also got cases where a person dies and there aren't embryos or sperm or eggs, and then people are wanting to say, did this person want to reproduce? Can we get posthumous sperm, for example? You can't get posthumous eggs, but posthumous sperm. I've had a case where a guy was in a motor vehicle accident and decapitated. His mom wanted to extract sperm. The only son, single mom, last of the line. And the quick thing is you can't actually do that because only a spouse can declare reproductive intent. And actually, if you try to obtain the sperm in these cases, they will be caught up in the courts forever because there isn't so without express intent, that's important. So that's one of the core things for posthumous reproduction, getting an attorney if you are interested in that, in addressing that issue with that intent. The other one is that we see spouses where one may have cancer or may be being deployed, for example, working overseas where there's a higher risk of mortality from being in issues. And so there's usually a year expected for a moratorium or grieving period before you use DNA without expressly intended writing saying that we are actively trying to conceive. We will do this even if I am to pass away while serving our country or doing other things like that. So that's another important thing to address with a reproductive attorney. Have you had any cases in this where you're saying there was something somebody got wrong thinking about it or they didn't think of? What would,
I've had a phone call from a person who actually was located in California.
Yeah.
Her brother had been in a very bad, fatal car accident, and she went to the hospital. And there's a finite time period where you can extract sperm. She asked that his sperm be extracted, and they did, but they had no authority. Yep. And she didn't have a power of attorney that addressed this very issue. And so she took the sperm home and she put it in the refrigerator. And she said, "What do? I can't, no one will freeze it."
Yeah.
And I said, they have no authority. You didn't have authority to get it.
Yeah.
They have no authority to freeze it.
Right.
And so she said, what do I do? You can't do anything.
Well, more than that, also, if you put it in the fridge, it's gone within 24
hours. She said, how long do I have? And I said, well, you don't have time.
Right.
So it really was just a non-issue. And so that is just sort of a advisory. You can't just request. There's a little bit of case law out there where some people have tried to say that it's organ donation. Oh, this person was an organ donor, therefore.
And by the way, for context, remember the FDA treats IVF as single-cell organ transplant for when we're doing third-party reproduction. So someone else from outside the relationship, so you have to do all this test for HIV and all these other things because it's considered organ transplant. So this is where some of that comes from.
It is, right. Yeah.
For context. So.
Okay, so circling back to the estate planning, the death issue, I would encourage everyone to really go into the process. When you come to see Dr. Parry, you go into the process thinking, when you are creating embryos or if you are, freezing any genetic material, it's generational, right? It can be generational. It doesn't have to be, but you have to think of it in that way. And I will also tell you that because we are so, new in this issue, I feel like there are going to be issues with children possibly having their siblings, right?
So
inheriting their parents' embryos, right?
So there was a case where a woman, again, she went through ovarian failure. Her mother had banked embryos from having had her. And then she used the frozen embryos for having a child.
Right.
And so, but there are a lot of complex things going on, and we are hearing through Ancestry.com, hey, the person you thought was your mom, no, she happens to be your sister and raising you, and here's what really happened.
Right. And there's no framework in the law, really yet, in any state to deal with, is this, a sibling genetically, or is that your child? Well, because you have a birth certificate, I guess it's your child.
But it is complex.
It's going to have to be cleaned up at some time.
And this is one other thing. Let's just start talking about donation. By the way, as we talk about things for family members carrying children. For instance, if we use a gestational carrier. So, by the way, definition very important. Surrogacy is the person carrying the pregnancy. It's also her eggs. Right. Gestational carrier, the person's carrying the pregnancy, but it's someone else's eggs.
Right. So another terminology for that, a lot of times you'll hear traditional surrogacy. Yes. That means the carrier is actually the biological mother of the child. It is her egg, and it is being fertilized, and the intent is to hand the child over to the intended parents, right? Yeah. But there are no guarantees. Right. You could just can't do it.
And to talk about that just briefly first, so again, we don't do traditional surrogacy. We use gestational surrogacy. I like the term gestational carrier to make it clear. But the reason is a lot of states have and I don't know if you use this term, but the 3-factor rule or something like that, or do you use that or
no?
Okay, so it's really if you're the genetic mom, the birth mom, and currently raising the child. You have 2 of those 3 things. It often is hard to take a child away from them.
Oh, right, sure.
And so if you have, a lot of LGBTQ, for lesbian couples, one will donate the eggs, the other will carry, and both will co-raise. Sure. Both of them have 2 of the 3 for each having a impact and connection that in many states the courts recognize. We'll come back to this as a topic because here in the South, it's a little more complicated.
That's right.
But at the same time, that's one of the things for how do you establish the genetic relationships or that ultimately give you more of a case for saying this child is also mine relative. I've seen a case in Wisconsin where basically a lesbian couple had a child. One person, they used donor sperm insemination. So it was one woman's eggs and she carried. The other had no genetic relationship, co-raised. Well, when the The mom was killed in a car wreck. And the parents of the daughter who had passed had objected to the relationship and claimed custody for that child and won.
Wow.
Despite her other mom having been there all along, done everything, but she wasn't the birth mom and she wasn't genetically related.
Right.
Donor sperm. And this is kind of silly. Let's switch over to this, and then we'll come back to gestational care for a bit.
Right.
If you have a guy who has testicular failure and uses donor sperm,
mm-hmm.
and they conceive and then they have a child,
mm-hmm.
I don't see anything in the South where the courts have a problem recognizing him still as a dad if the mom were to pass.
Agreed.
But if the exact same thing happens with a lesbian couple, even if they are married, then there can be complexity.
Right. And so, sometimes we try to even that playing field with a confirmatory adoption for same-sex couples.
Right.
And it is another option that I feel like a lot of same-sex couples are aware of, but some may not be. When you have a by definition, right, you're always going to have a biologically related
yes.
partner and then a non-bio partner, right? And so for instance, a divorce scenario, depending on what jurisdiction you're in and depending on the judge, the non-biological parent may not be on the same playing field as far as custody and all of the rights to the child. So we try to do a very simple confirmatory adoption.
So what do you see the advantage? So confirmatory adoption obviously is the strongest.
Mm-hmm. What
do you see for the balances relative to a parentage agreement versus confirmatory adoption for things?
Yeah, so another option could be a co-parenting agreement. A lot of jurisdictions recognize co-parenting, and they also will honor the fact that both parents are going into the birth with the intent to provide you're getting the rights and obligations, right?
Yeah.
Have all the rights to the child, but also take on all of the obligations.
Could you define like parentage agreement and a confirmatory adoption? By the way, for people who don't know what we're talking about,
right?
These things.
So a confirmatory adoption will look differently in each jurisdiction. So you would have to definitely, consult with a local attorney on that. But it basically is an adoption that indicates that both parents are going in with the intent to raise that child and have already taken on all of the obligations of the child and are co-parenting currently. And so I always explain to the judges, this is a belt and suspenders type motion. And we waive the different traditional adoption requirements like a home study. Well, they're already raising the child.
Right.
And then, so we waive a lot of the various traditional safeguards in an adoption, which fully makes sense in a traditional adoption.
So it's streamlined.
It's streamlined.
And
it makes sense to the judges for the most part. And sometimes, we have to explain things and say, here's what we're trying to accomplish. But at the end of the day, we're trying to accomplish equality in parental rights, right? And
so that's for confirmatory adoption. What's a parentage agreement?
So that can really be a statement of intent, honestly. It can look differently for each couple. And it really just solidifies and puts in writing everyone's intent with regard to how this relationship plays out with regard to the child.
Yeah. But the quick version is, when I talk to couples where their relationship may not be recognized as much in the Deep South and other places, I'm saying, hey, got to think about these things. Talk to an attorney. I just want you protected.
Right.
And that's a very normal thing to work about because not everyone, even if you were married in for things, some people just may not recognize the divorce. And I've seen cases where a lesbian couple will divorce and they will say, I'm sorry, it was not her DNA and she didn't do it. And she was really a support person. And then all of a sudden, as you alluded to, that other partner is left out in the cold and
Right.
fighting harder to
Right.
get the rights. And it can relate to the politics, the faith, all these other things of the judge that you get.
Right.
And you don't want that variability.
Another, and we've been talking about divorce, but another aspect in the death space is, let's just take the scenario where the biological mother, right, dies. And so she has a partner who has, again, raised the child, from the beginning, had all of the obligations of, the monetary obligations and whatnot for the child, supported emotionally. Let's just say the deceased mom's parents say, no, we are the biological grandparents, right? Yeah. And you're not even the biological parent. And so we're going to fight for custody, right? So in that scenario, depending on your judge and your jurisdiction, it's a fight. It's a real fight. So the more that's what we're trying to clean up.
Right. The more you have things set in advance that protect your rights, the more likely you are to do well should something complex happen.
Right.
And so even if you don't do it, this is one of the things I say, even if you aren't setting up, confirmatory adoption, parentage agreement, just even talking about where things can go awry and knowing about them is half the battle. So talk with a good person about that. Like Ashley Pittman.
Half the battle.
It absolutely is.
That's right.
Now, what are the things when you get, so first of all, for a lot of egg donation, it's usually anonymous. For sperm donation, usually anonymous. When people are using and the things I worry about, while you have people sign waivers and, say this is fully, we no longer own this DNA that we give these gametes to you. At the same time, you really have to do a lot for just saying, hey, let's go through, if you know this person, let's go through psychological screening. You don't want the person at the Thanksgiving dinner table feeling entitled to comment on your parenting abilities when family members donate things.
Right.
It happens. It really does. And but at the same time, and usually with well-designed contracts for anonymous, it should be a non-issue.
Right.
At the same time, people are going through variations. What do you see from where if people have donated, that people are informed, that people are having to communicate, hey, I found out I have this genetic condition. What's the obligation for that? This child can contact me at this age, since a lot of people may find out anyway through Ancestry.com.
Yes.
What are you seeing for sort of the more complex variants when there's a known donor involved?
So the future contact and the involvement and who has the authority to decide that is a really big issue. So I have a couple of different types of cases with known donors. The family member who's a close family member, I have in my contract, usually if they intend for, let's just say the sister is the donor donating to, her biological sister. If she's going to be, if the donor's going to be in that child's life as an aunt, then my contract, and everybody intends for everybody to get along as that, in that relationship, then the contract states it. We intend that, the donor is going to be involved in the child's life in a familial relationship.
Right.
And so that is all stated. Now, what if it's a friend? So that's a little trickier because a lot of times the parties will agree that they're going to have a shared email address, right? And they're going to keep this, let's just say it's a Gmail. They're going to keep it open. And it is going to be for the specific purpose of sharing pictures once a year or at some point in time, usually around the age of 18, they will determine that the child can receive the donor's full contact information. Right. And this email address would be provided to the child. Whether the child would like to use it is completely up to the child. So, but who has the authority to, cut off communication possibly? If someone is, let's just say, trying to contact the child, say I'm your biological parent, maybe even take parental rights, that kind of thing, who has the authority? Does that
Get a good contract beforehand, by the way.
Does that
sure.
donee have the power to cut it off? You know, right.
And that can be, again, stalking. There can be all kinds of things that are intrusive with that. And again, while these conditions are rare, they're non-zero.
Sure.
And the more you can do to protect on the front end, the more you are likely to be in a situation that you want and that is healthful, that everyone is getting out what they want. And by the way, again, for when it's known, the ability to say, okay, this is what we're agreeing to. For so that basically the expectations are spelled out, that nobody has any doubt. The very act of creating the contract emphasizes the clarity for the relationship going forward, which is essential because you don't want to have someone change after the fact.
Right, for sure. And then also another big issue is what do the parties intend with regard to if their family's complete at any point, or if they die, do the gametes or the embryos revert back to the original donor? And a lot of times they will. And then also another issue is, we have multiple donations, right? Yeah. Sometimes we'll have the initial donor, and that donation contract will say, you donee once your family is complete, then you'll decide that you would like to transfer them back to donor.
Right.
Then donor then transfers them to another couple in need or person in need, right? And so I have had cases where, the donor's embryos the rights have passed more than once to more than
and remember, think about
one
it. If you
third
have
party.
Also, let's say husband and wife, they use an egg donor who's a friend. The husband's sperm then fertilizes those eggs, but if they've done their family goals and then the embryo reverts back to the original donor,
right?
But then it happens to be the sperm of the husband, then what happens to that? It can get very complex.
It is very complex. It is very complex.
And
it's only getting more complex.
Yes.
Right? As the time passes and the generations and as the embryo, freezing grows and the egg freezing is really growing because, there's just a lot more fertility benefits offered now by the bigger companies usually, but honestly, the smaller companies are getting involved. So this is allowing the younger females that otherwise may or may not have had that kind of money to freeze their eggs. It's allowing them the freedom to freeze their eggs earlier, and they're using those benefits. And so egg freezing, as you probably see, is increasing around the country.
I used to be kind of opposed to it because I found that, if you look from 20 years ago, 10% of people would use it, their eggs, and they'd be spending a lot of money with most of the time they wouldn't use it. Now, with a lot of insurance coverage, with much more success with egg vitrification, you're finding upwards of 50% of people will use their frozen eggs. And with the cost down and the yield higher and pregnancy rates higher, it's something that I think is much more of a right fit for many people as they're exploring, hey, I want to keep my options open for my family, even as I pursue my career, and not have those timelines. So I've been a convert, but we had to progress a little bit, I think, for the technology.
That's right.
So, okay, to move away a little bit from donor, and again, remember to go back to the essentials we were talking about. You want to figure out parental rights, you want to figure out financial obligations, you want to figure out future contacting, updating of medical information if someone is to find they have a major medical condition, should this be passed down, boundaries for involvement. Okay, let's switch gestational care.
Okay.
That's probably one of the hardest things because you're getting really in agreement with a woman who will be carrying a pregnancy for another couple.
Right.
You have to address, again, what happens on the birth certificate, what state they deliver. You have to talk about even, what they eat or whether they smoke or drink in pregnancy, all these types of things,
Yeah.
So walk me through some of the top things that you talk about with people.
Yeah.
For the GC agreements.
Okay, so I'm going to back up and go a little broader.
Okay.
Just to preface that conversation. Okay. So there are, in a gestational carrier journey, there are two phases of the legal process. And so the first phase is going to be the contract phase. So we have a gestational carrier agreement that we're about to talk about and what all that covers.
Yeah.
And then there are always two attorneys representing one side or the other. So we always have representation on both sides. So the attorneys come in, they negotiate the agreement for the parties. Once everybody is happy and they sign off, then the attorneys step away, and then you do your job to create the pregnancy. And then yay, we have the pregnancy. And then we jump back in. And so then the next phase is the determination of parentage in court. And depending on the jurisdiction, this can be less involved or more involved. You just would have to go state by state on that. But the determination of parentage is essentially a court order that names the intended parents as the legal parents of the child that the gestational carrier is carrying and delivering. And so what that means for the intended parents is that they can be treated as the parents at the hospital, which is really important to these intended parents because they have gone through this journey, and it is collaborative reproduction in every way, right? And at the hospital, they are, usually at least maybe in the delivery room, but they don't have to be, but they're involved in every way. And a lot of the hospitals, if you have that court order, will allow the intended parents to actually get a hospital room during the delivery and on the labor and delivery floor so they can have that full experience of feeding the baby and whatnot.
Right. Well, and even beyond that, by the way, there is, we can actually make it so even though a woman did not give birth, we can actually prime the body so that she can do breastfeeding herself.
That's right.
And so that she can also be there for that, being in the hospital. There are a lot of things that can be done, and it's just a matter of planning, being aware. And so this is another thing that is essential. Who gets to be on the birth certificate, how you've got that organized.
Right. So the second part of that court order is the intended parents get to name the child, right? Usually the application for the birth certificate is filled out at the hospital. Yeah. And the intended parents are able to name the child, right. And they're also able to get their names on the initial birth certificate. Now, there are a few states where if you have a donor gamete, yeah. You might have to come in after the birth with either a post-birth order, right. Or possibly, depending, some sort of determination of parental rights because there was a donor gamete. So
to clarify, so there are pre-birth orders and post-birth orders, and
right.
Ashley is alluding to the fact that you want to do as much as possible for pre-birth, so it's as clear as possible, and then when things get complex, it's worse to fix it on the far end of things.
For instance, Tennessee, yeah. Right? So Tennessee, by law, if you have a donor egg, yeah. You will have another proceeding after the birth, yeah. To just kind of clean up that, affirm the intended parent. So we have two phases, and so the contract phase can be very, very simple. Usually if there's an agency involved, so we have independent journeys where there's not an agency involved, and we have agency-led journeys. And so the agency, if there is one, has usually, really kind of worked through a lot of the benefit package, which means all of the compensation that's going to change hands. And so they've sort of worked through all of this with the parties and helped the parties. There's the gestational carrier has to get medically cleared, right? Make sure she's healthy enough to carry a pregnancy and ensure success in the journey. There's a psychological evaluation that happens before the attorneys, both of which, need to be already secured before the attorneys get involved. So a lot of times when there's an agency, all of that has been ironed out before we come in and start trying to, put it in writing and make it, all official.
To allude to what Ashley's also talking about, there's so much that can go into this. It's not just that for those agreements, but for instance, you want to be able to figure out who covers the insurance for the delivery.
Right. The medical insurance. Is the gestational carrier covered by medical insurance?
Right.
If not, what are you going to do?
How do you address which state things happen in? For instance, if you have multi-state agreements, what state overrides or determines these types of things?
What about international?
International, even more complex.
Lots of international.
And to even go a level also beyond that, who makes the medical decisions if something complex arises? Let's say there is a lethal anomaly. For instance, some people would say, if this is not a viable pregnancy, I don't want it to continue.
Right.
But the gestational carer has autonomy over her body.
Right. At all times.
How do you find the right balance for that? There are cases I can think of one out of Rhode Island, where the very severe defects for the pregnancy,
right.
debatable for viability versus how long. And the parents said, we do not want to have this continue.
Right.
And the gestational carrier went off to Michigan, had the delivery, and then also sued the parents for also the costs of caring for this child, even though, very brief lifespan or things like that. These are things that can happen, and you want as much as you can ironed out
right.
for these rare cases.
So I personally have a bifurcated healthcare power of attorney.
Okay.
That I will, once a pregnancy is achieved, I will have the gestational carrier and the intended parents agree that she can execute a healthcare power of attorney, which authorizes her to name an agent.
Yeah.
For decisions that she can't make on her own behalf with specific regard to her body, right? If for whatever reason, her health is at stake, if she is capable of making the decision, if her health is at stake, if she is capable of making decisions with regard to her body, then she has the autonomy to do that. And then she is naming an agent in case she can't, but she's also naming the intended parents to make decisions on behalf of the unborn child.
Right.
That is not perfect.
Nope.
It is not perfect, but it is in writing, and it is a way that we are trying to deal with how do you make these decisions? And then from the medical aspect, from the medical perspective, who's your client? Who's your patient? For me, it's who's my client. For you, it's who's your patient.
Right.
It puts the doctors in a really hard position.
Well, and this is why you do as much as you can, so that everyone's in agreement.
Yeah.
The simple versions for this, for example, are you have, for instance, single versus dual embryo transfer for a gestational carrier. Mm-hmm. 50, while the national standard is for single embryo transfer for any IVF cycle, for gestational carrier, if you can get twins and have both the children of the goals in one fell swoop, a lot of people want that. We've actually published on this, by the way, for trivia. But if you are to say, if you get to the day of the transfer, and the gestational carrier says, no, I'm only getting a single embryo transfer back, I don't care what you said.
Then you're only transferring one.
Then you're only transferring one. To put more back actually constitutes assault. Mm-hmm. And so therefore, it is actually a very serious issue. So you've got to make sure there are all these agreements well in advance that people are agreeing on things, and then it can be, of course, a far more complex, for who gets what, for things. I mean, what have you seen when people have had disagreements after contracts? Because it happens.
Oh, I have a case now where the contract had been signed, everyone was on board, everything was great, and she got pregnant with her own child before they had an opportunity, to transfer an embryo.
Well, and in that case, so there's a degree, we talk about that for the importance of contraception, and you even have to have for a gestational carrier, the husband signing off also for the gestational carrier as also being involved. But what do you have, for instance, for the gestational carrier, personal liability were they to do things that breach the contract? They get pregnant. This couple has spent thousands and thousands on this gestational carrier that the gestational carrier now has just wasted. Or the gestational carrier says, hey, this is a pregnancy that we did not agree would go forward. Or in these cases, how much are the intended parents still liable if the gestational carrier makes a decision that's contrary?
A real quandary in the industry.
Yeah.
So in conferences, with attorneys who practice in this area, we discuss, how do you handle this? Because as a very, very general rule, and it's not every case, but as a very general rule, the socioeconomic level of the gestational carrier is usually less than the intended parents, because they have the money to go through this process. Yeah, they do. And so you have that sort of knowledge and discrepancy going in. And then some contracts will say that she has to pay back everything that she has received until the time, it is determined that she is pregnant with her own child, which, by the way, sometimes can be after the birth, right?
Wow. Yeah.
Because contemporaneously, she may have gotten pregnant along the time that the embryo transfer took place, and then the baby is born, and for whatever reason, they maybe even look at the baby and say, this cannot be my child, right? And so in that case, she's received everything. Right. But how much has she spent?
Right. And by the way, on that
she may
note,
not have it.
I have actually gotten forms where I have to sign and say, this person we were monitoring beforehand. We did not see dominant follicles leading up to the transfer and all these things.
Yeah.
So we, in all of our medical knowledge, believe this fully to be the biologic child of the intended parents and not the gestational carrier.
And that gives the intended parents comfort.
Yeah.
And it protects you from some liability, right?
Yeah.
Yeah. So that is an ongoing discussion. The caveat to that also is that, in every contract, there is usually some sort of mediation clause or some sort of dispute resolution. And at that point, the intended parents may be able to pay an attorney or for a court proceeding or, whatnot, whatever that looks like as far as dispute resolution. But what if the gestational carrier doesn't have the money to pay? And, for instance, in a couple of cases, I've just sort of, tried to iron out all of the differences and discrepancies and for no charge. Yeah. Because I just feel ethically, I feel like there's an ethical obligation there to at least, put in some time to help, with dispute resolution. But there may not be any money in the gestational carrier's pocket for any of it. Yeah. So it's not a great solution.
It isn't. But I love that you try to do right by those entrusted to your care.
Oh, yeah.
That's a part of our mindset. We all are in this because we care deeply
about
it.
Absolutely.
And believe in it. And that's a great thing. What are the, so that we don't exhaust everyone from watching this, we're passionate about, we'll be talking all day.
We can do this all the time. Yeah.
And what do you think are essentials that is there anything that we should have brought up that we haven't for core issues where you bring value as a reproductive attorney or that people who might need one might not be aware that they need?
Quite honestly, I would encourage everyone to visit, we call it Quad A, if you don't mind. But I think it's a great resource. It is a group of attorneys. It's called the Academy of Adoption Assisted Reproduction Attorneys. That's what it is. Sure. And so it is an organization that is both in the United States and international attorneys who have to prove that they have worked a certain number of domestic and international cases in this area. And it is a pretty strict requirement to join as a fellow of this organization. But the website has for every state, and we need to do a better job of probably compiling international attorneys because we all work very closely with some very good international attorneys. But in every state, you can just click on your state and you can see who is doing assisted reproduction law. You can see who's doing adoption law and who is a fellow. And some fellows have adoption and assisted reproduction. So you can see where they are. You can have contact information. It's a great resource for finding a very well-qualified attorney in this area because it is a very intricate and niche area. And it's a stiff learning curve for, you can't just practice family law and then, and honestly, I can't, I'm not going to take a bankruptcy case, right? So
I do not do cardiology.
I am not
a cardiologist.
I am not either. I am not touching any of that. Right. So it's really important to have that kind of a resource to go to find, your very qualified attorneys. And so in almost I almost never have cases where all parties are in the same state unless they're related. Yeah. So almost always there are parties in numerous states, possibly numerous countries. And it gets very complicated when, you start getting into some of the ancestry of, let's say, international clients where, you have to combine a couple of different legal qualifications of a couple of different countries, and then you have the birth in the United States. And so you have to work through local counsel with the home country. Yes. And it's important. It's important to have your team. Yeah. Yeah.
The right people make a world of difference. Yeah. You just inspired one thing I meant to bring up that I forgot to talk about, which is also for talking about donor sperm. There are a lot of women who are single, same sex, for the relationship, they're wanting to just use a friend as a donor.
Right.
And unfortunately, or fortunately, in a lot of states, that is not recognized through the courts unless it goes through a fertility clinic. So when the guy provides a sample, provides it, they bring it home, put it back turkey baster style. There have been cases where things have gone awry.
Right.
Where the guy says, hey, you know what? I never had kids of my own, and then sues for visitation rights.
Yeah.
Or the parents or the parent ends up going bankrupt and then suing for child support.
Right.
So if you are ever thinking about using a known donor just as a friend, socially, whatever, you want to make sure all those things are spelled out through a reproductive attorney before getting into any trouble for things.
Don't make a handshake deal.
No.
Don't make a handshake deal. It could turn south.
These are important things. Who's the father of a child?
Yes.
Or mother.
Yes.
That matters. Well, Ashley Pittman, again, phenomenal reproductive attorney. Thank you so much for coming on this. We could talk forever. I'm sure we'll probably do another one at another point because we've got far more than we can fit into this to discuss. But again, for all of you watching, if you have questions, she is phenomenal for things. There are many reproductive attorneys. I am not promoting any individual for things, but I do recognize her excellence. And remember, this is general medical information, general legal information for your own personal practice or needs. You want to coordinate with a clinician or an attorney. And if you have questions, write them here. We'll try to cover things. And good luck for where you are on your path to parenting. And like, subscribe, and thank you so much.